So as you are quite aware, the last 3 months have been quite exceptional. With that in mind, I've got, although this is primarily about the updates in legislation this year, we have of course had a host of coronavirus related rules and codes and acts updates and all that sort of thing. So I'm going to start with that and then move on to the other acts that are, or the other legislation that is coming in. Now, let me see. Yes, here's my, I'm just going to go through, I'll go through these in more detail as we move on. This is in relation, the last 3 months pretty much, we have had the Coronavirus Act, which was, came into force on the 26th of March 2020, as that was got to be the fastest enactment ever, and try to deal with anything that may relate to anything that could be affected by the coronavirus. We have a Practice Direction 51Z, which is in relation to civil procedure rules, and possession claims fall under the civil procedure rules, so that has affected tenancies. We've had temporary right to rent changes, so changes to the Immigration Act, just as a temporary measure while we have issues at the moment in respect of social distancing and self-isolation. There's also the draft Coronavirus (brackets Protection of Assured Tenants) close brackets bill, and that is hurriedly being travelling through Parliament at the moment with a view to potentially being enacted quite quickly. And there's also talk of a pre-action protocol for the private rented sector in line with what already happens in the social housing sector. So I'll talk a bit about that in a minute. So in relation to the other legislation that I will talk about, Homes Fitness for Human Habitation Act 2018, which actually came into effect for new tenancies on the 20th of March 2019, but it affects all tenancies from the 20th of March this year. We have the Minimum Energy Efficiency Standards Regulations, which is MEES 2015, which again affects all tenancies from the 1st of April this year. The Tenant Fees Act, which came into being last year on the 1st of June, affecting new tenancies from the 1st of June. There's been a year's transitional period, and from the 1st of June this year, it affects all tenancies. And the Electrical Safety Standards in the Private Rented Sector Regulations 2020 has already come into, has been enacted, but it affects new tenancies from the 1st of July 2020. So I'll go through these in a bit more detail. The Coronavirus Act, as I said, was hastily brought in to cover many issues, and the ones that are particularly in relation to tenancies that affect landlords and tenants, Section 81, which basically said that no evictions could happen because of the coronavirus. Schedule 29, all eviction notices have to give a 3-month notice period, and that is up to the 30th of September 2020. So even if we're over things, we still have to use the new forms. There was guidance in relation to buy-to-let mortgage holidays not affecting credit ratings, and the Financial Conduct Authority having recently considered their code. I just looked at that, and basically it says that there can be no mortgage repossessions at all by lenders until after the 31st of October 2020, in the hope that any issues in relation to unpaid rent which affects the payment of a mortgage might be able to be resolved before then. In relation to the Coronavirus Act, which talks about the notices, obviously notices for eviction, we've got Section 21 and Section 8 under the Housing Act 1988, together with notices to quit for licenses. The legislation now is that all notices must give at least 3 months notice, regardless of what the contract said, regardless of what the Housing Act says at the time that the tenancy was entered into. It's got to be at least 3 months. There are new Section 21 notices, and they have separate notes that must be given to the tenant as well. It's important that in this period that these are used. There's a new Section 8 notice which sets out information in relation to the Coronavirus Act. And there is a new accelerated possession claim form which you use after a Section 21 notice if the tenant hasn't left. And I have done a couple of accelerated possession claims recently where Section 21 notices served before the new legislation came in, so were valid or are valid, and but they've expired in this coronavirus period. We've proceeded with accelerated possession claims, which you can do. You can send claim forms to the court, they will issue them, but they immediately put them on a stay until the stay is lifted. So they have changed quite dramatically. The accelerated possession form has gone from 7 pages to 17 pages, and it requires attachments of the how to rent guide, the energy performance certificate that you served on the tenants, as well as the usual tenancy deposit scheme and this certificate and the Section 21 notice. You also have to attach the gas safety certificates, all gas safety certificates that are relevant to the tenancy that have been given to the tenant, and put all the dates when each gas safety certificate was attached. There's also provisions in respect of HMOs, and it's very, I think it's typically looking at trying to prevent, if there's any way of slowing down or stopping Section 21 or accelerated possessions, they're trying very hard for that to be the case. Fortunately, the landlords that I have done this for have kept really, really good records, so we were able to complete those. But again, we're not able to do anything. They've been issued, so they're in the queue. So it's a case of waiting until the stay is lifted. Practice Direction 51Z is in relation to the civil procedure rules, which governs civil claims, and possession claims on the whole fall under this. There are some tenancy issues that potentially fall under the criminal courts, but I'm not dealing with those today. So Practice Direction tells lawyers and people doing advisors, judges, how things will progress. So there was a 90-day suspension of all possession claims. This was issued by the court in addition to what the government had said under the Coronavirus Act. It was initially until the 25th of June 2020, and since last Friday, this stay was extended to the 23rd of August 2020. This, they have said, is primarily for them to consider the bills that are going through to try and bring in the extra temporary measures. It doesn't include trespass claims. So if you have trespasses, you can bring a possession claim for trespasses. However, in residential properties, it's illegal for squatters to occupy, and the police should deal with those. If there's commercial property or maybe a holiday home or something like that, you may be able to that. It's basically trespass claims against persons unknown. There are trespass claims that you can bring when a licence comes to an end, when an occupant is living there without consent, but that isn't, it would appear, included in this. If they've already had a right of occupation, then it won't be the case in here. What it could include, I've had instances where people have decided to set up tents on private land in a block of flats, and the police do not want to get involved with removing them because it's on private land, and in this case a trespass claim would be the way to go. The stay doesn't include claims for an interim possession order. Basically, this is again trespasses, but it's a very fast way of getting trespassers out, certainly temporarily. It tends to be, again, in relation to commercial properties or not residences, because you should be able to get the police to remove squatters. And an interim possession order has to be of a building as opposed to land. There has to be a dwelling there, or a building. That's quite effective because there are very tight time frames. So within 28 days of knowledge of persons unknown occupying, you make your application to the court. They issue it there and then, and within 24 hours of issue, you've got to serve it, and that means there's all kind of service issues. But within 24 hours of being served, the occupants have to leave, or it's a criminal offence and you can get the police in. Now it goes on, there's another hearing, but basically in that time, they have to move out. It also doesn't include money claims for unpaid rent, so you can proceed with that, but of course you have to consider the costs involved, like the court fee, and whether or not you're likely to get your money. Has the tenant got the money, or are they just not paying? Would this encourage them to pay? I've had some actually that have paid up because they don't want a judgment, but of course if they can't pay, then you need to, and they may defend, and there could be issues, so you just need to think about that. Also, you can obtain injunctions for antisocial behaviour or to prevent somebody from doing something, so that's not included in the ban. Now, the right to rent changes is to do with the Immigration Act, which came in since 2016. We need to carry out, landlords have to carry out, or letting agents have to carry out right to rent checks on tenants. But because of the issues in relation to social distancing and self-isolation, the tenants now must send the landlord or the letting agent ID, well, it's the landlord's responsibility ultimately, identification by email or mobile app, so a photo, screenshot or photograph of a passport to the landlord. Then there has to be a video call where the tenant shows the document on the screen. The landlord records the date of the video check, prints it on the copy ID, marks and the justice check has been undertaken on, put the date in there due to COVID-19. But once we're allowed and the lift is, the lockdown has been lifted, then we'll have to do it properly and see the original and keep a copy as you would normally during the tenancy and for up to 12 months thereafter. But this is a temporary measure that should be happening now. The draft Coronavirus Protection of Assured Tenants Bill, this is what I think the government are working on very hard to bring through Parliament while the ban is there, or while there's a stay. And it's basically looking for temporary measures up to the end of this year. And in respect of Section 8 notices, Ground 8, as you may be aware, is a mandatory ground for possession where there are at least 2 months of arrears at the time of service of a notice and at the date of a hearing. There are other discretionary grounds. Part 1 of Schedule 2 of the Housing Act 1988 lists mandatory grounds for possession, and Ground 8 is one of those. They want to move Ground 8 out of Part 1 and to move it into Part 2, which is discretionary. So at the moment, the courts don't have a choice. They have to grant possession if it's satisfied that the tenant has not paid rent. It can be proven that it's at least 2 months at the service of the notice and at the date of the hearing. But they're going to, or they're hoping to, move it into a discretionary, so it's up to the judge to decide if it's reasonable to make such an order. Also in relation, I didn't say about notice periods, whereas for the 3 months, ground 8 used to be that you had to give 2 weeks notice to the tenant before you could bring a claim, but that is 3 months. So they're all, basically it's 3 months for anything that says not just section 21 but section 8, and the any notice, even you know, for the secured tenants that might be different notice periods. It's now 3 months across the board, basically, for whatever, for a breach or for no fault possession. It's going to be 3 months notice. So also they're seeking to make section 21 possession orders discretionary at the moment, as long as you've satisfied this 17 pages as it is now. And as long as you've provided everything, then the judge does not have any discretion. He or she has to make the possession order, but they are seeking to move that to where, instead of saying the judge must do something, whether it will be may do something if it's reasonable to do so. There, as you may be aware, there's the Renters Reform Bill, which is seeking to remove section 21 entirely, and I have spoken about this before, and I think this is the way that they're moving at the moment. So there's also talk of a pre-action protocol for the PRS, and pre-action protocol is again under the civil procedure rules, and a lot of types of claims do need to follow a pre-action protocol before you bring a claim. So construction or debt, social housing claims, mortgage possession have pre-action protocols to follow before they're allowed to take the matter into court. Now, there isn't one yet for the private rented sector, but this is what they're working on and hoping that that they will be able to follow such a thing. So I'm just going to, I don't know, we haven't had a draft or anything, so this is what the social housing pre-action protocol looks like, and basically it's to encourage contact between a landlord and tenant, to avoid litigation if at all possible, to agree affordable sums to repay the arrears. Landlords, social housing landlords have to provide rent statements to the tenant quarterly. And the landlord has to help tenants with any benefits applications that they might be entitled to, and to contact the DWP to have rent paid direct to landlords, particularly if there are arrears. And the government website has a quick link now for landlords to complete an application in order to have the rent paid directly to them. I think given all of the delays that are happening, this is definitely the way to go without even the pre-action. If you can come to any kind of agreement with your tenant, that is the best way, especially if they've been good tenants before, because I can't see possession orders being made until the end of the year, realistically. Some may get through that have already gone to court. Some landlords find that tenants just will not engage, and then the pre-action protocol does fall away. And if you can show this, it's very, very important to keep records of everything, every conversation. Even if it's on the telephone, you should follow it up with an email ideally, because that gives you dates and times. If your tenant doesn't have email, then you can just follow it up with a letter. Try and keep everything in writing. If you're having trouble getting contractors to carry out works, then keep a record of discussions and emails with them. So what you need to show is that if it comes to going to court, then you can show to the judge that you've been reasonable in trying to sort this out, and to deal with it. But I do appreciate that tenants don't always engage with landlords, especially if they know they can't pay the rent. I've acted in some sort of negotiations as well, which has helped. Sometimes it helps to have a third party take away that heat between the parties, and we have managed to settle a few. But you know, that's but if you've got a good relationship with your tenant, trying to do that is a good thing. it might mean that you'll at least get some rent rather than none at all. So that's definitely one to look at. Now, leaving COVID-19 behind, we've got the Homes Fitness for Human Habitation Act 2018, which came into effect, affected new tenancies from the 20th of March 2019. But since the 20th of March this year, it affects all tenancies of dwelling with a term of less than 7 years, including those created before the 20th of March 2019. It does also apply to social tenancies, and some of those will actually have a term greater than 7, but that's different. But as far as ASTs go, we're talking about less than 7 years. Introductory tenancies or protected tenants, assured tenants with greater security or greater term than 7 years are also included. And tenants will have the right to bring claims against landlords for the presence of hazards. At the moment, or sorry, prior to this, it was only the local authority, environmental health, who could do this. Now this has given a right to tenants to take action, and it's obviously in landlords' interest to keep their properties in a fit state for, you know, they've got an asset there, so want to make sure that they do. And I'm quite sure that most people who watch webinars or are members of landlords associations and that type of thing are quite sensible about these things, but it's worth knowing about. So it updates sections 8 to 11 of the Landlord and Tenant Act 1985, and there's new sections that have come in at 9A, 9B, 9C. And the Landlord and Tenant Act basically sets out what your repairing obligations are in relation to a short lease, and a landlord, whether it's in the tenancy agreement or not, is an implied term anyway. And landlords basically are, under the Landlord and Tenant Act 1985, required to maintain the keep in repair the structure and exterior of the property, including drains, gutters and external pipes, keep in repair and proper working order installations for the supply of water, gas, electricity and sanitation, including the bases, sinks, baths and sanitary conveniences, and to keep in repair the installations for space heating and heating water. And they've now included within the Landlord and Tenant Act the prescribed hazards as set out in Section 2 of the Housing Act 2004, which are the hazards that environmental health would be looking at. So they're now incorporated within this. Exceptions are issues caused by the tenant's failure and problems caused by the tenant's own possession. So if they bring something in that causes damage, then that's not going to be included. Acts of God, storms and floods, obviously you'll want to deal with the issues anyway. And where the landlord will be breaching an enactment by carrying out the repairs. So listed buildings, consent if you need planning permission or you need consent, then, and if you can't get it or to do so would breach it, then that's an exception. Where third-party consent is required and not given, so a freeholder or a superior landlord, and where the tenant is not an individual, so local authorities or housing associations. So I know some landlords let direct to housing associations and local authorities, and then landlords don't have a duty to those authorities because they will be subletting with permission to tenants, and they will be responsible for those issues to their tenants. So unfit for habitation, so this is repair, neglect and bad condition, unstable building, damp and mould, unsafe layout, so you don't want different levels, people falling, not enough natural light or ventilation, problem with the water supply and drainage and food preparation facilities, common sense really, basically looking after property and making sure there are sufficient facilities for your tenants. So the court action, compensation may be payable to the tenant, and you need, if you have tried to carry out repairs but the tenant's not allowed you in, if there are any other if there's evidence that that they're bringing this claim erroneously, that you've done everything you can, a surveyor's report will ultimately probably be needed to show that they're absolutely wrong to do this, and evidence is crucial to defeat the claim. And if you manage to succeed and defeat it, then they have to pay the landlord legal costs. Obviously, it depends on whether they have money anyway. So the local authority can still bring action against the landlord and use its enforcement powers, serve an improvement notice, remedial notice. I'm not sure oh yes, I've got a couple of questions there. Right, in these regulations, I'm sure you've all heard this quite a lot, so again, I'll go through this quite quickly, but if you want more information, I've got articles online, or please do contact me. So since the 1st of April 2018, landlords cannot rent out a property with an energy rating below an E unless it's exempt. And that has affected all tenancies from the 1st of April 2020. And I know some landlords who are having problems with it. And now that they've allowed it to continue to this period of self-isolation and social distancing, it's been a real pain. If you have an exemption, then you must register it on the PRS exemption register, which lasts for 5 years. So you need to review it again after that. Exemptions, there's a £3,500 cap. That's what you must spend in order to, landlords must spend in order to improve, or to not even improve, just to bring their property up to at least an E. But if they have done that, you can demonstrate that they have spent this, and on the energy performance certificate you see, the newer ones, there are suggestions for what improvements can be done, and rough estimates of costs. So if you can show that you've tried to do, that you've done some of those and you're still in E, that will be an exemption. If consent is required and cannot be obtained, or there are unreasonable conditions attached, then that is also an exemption. If a surveyor says the reduction in market value of more than 5%, then again, that's an exemption, but you do need to have evidence for this. There has to be actually a surveyor's report that actually states this. And if an expert says that there'd be a negative impact on the property, again, you need a report to actually say this, and then you can register on the exemptions register. The Tenant Fees Act 2019, so affected new tenancies from the 1st of June 2019. Affects all tenancies, social housing, student lets licensed to occupy from the 1st of June 2020, even those in existence from the 1st or before the 1st of June 2019 now. So letting agents and landlords need to both be aware of this. The Tenant Fees Act does refer to letting agents as well as landlords, so it is something that letting agents need to be aware of also. So I put the permitted payments here: rent, a deposit of not more than 5 weeks, not if taken before the 1st of June, and no renewal, but I'll explain that in a minute. Default payments, but it has to be no more than the landlord has had to pay, or it could be, that one is 3% above the Bank of England base rate, which at the moment is almost on the floor, but anyway, and that is if tenants don't pay their rent. Utilities, council tax and TV licence, obviously permitted payments, they must be paid, but anything else is prohibited. There are some for changes of tenancy. If the tenant wants to leave early, you're allowed to claim for losses, but they've got to be demonstrated, they've got to be shown that they're reasonable, and that they have been incurred by the landlord or letting agent. Sanctions for requesting a prohibited payment. You can't serve a Section 21 notice until it is repaid. And there's obviously a possible fine of up to £5,000, £30,000 for people who keep doing it. And officers and members can be personally liable. And that's in particular, obviously, corporate landlords and letting agents. Landlords notified of potential fine within 6 months of becoming aware of the breach. And they have 28 days to respond, and it's payable in 28 days. So if you've got something in your contract that says, that they've got to pay, for instance, for a checkout inventory, that's not binding. So you don't have to change your contract, you just can't accept or demand the money. Yeah, so anything that's, if your contract says it's just not a binding term. But if you accidentally take it, if they pay it without actually asking for anything, you need to give it back within 28 days. So the Deposits and Tenant Fees Act, no more than 5 weeks rent may be taken as a deposit where the rent is up to £50,000 from the 1st of June. Where it started before the 1st of June, if you took more than 5 weeks, so you took 6 weeks, 2 months, and it's just continued as a periodic tenancy before, if it became periodic before the 1st of June 2019, then there's no need to refund the excess deposit taken. Where the tenancy started before the 1st of June and has been renewed since, then you do need to return the excess. And the final thing now is the electrical safety inspection. So from the 1st of July, it has come in already, but it affects tenancies from the 1st of July 2020. It affects new tenancies and existing fixed terms that become statutory periodic after 1st of July. You must ensure that there's an electrical installation safety check and that a report is carried out and given to the tenant. It must comply with the 2018 edition of the IEEE wiring regulations. And there was a substantial update to this. So if you did an electrical safety inspection less than 5 years ago, it would be worth checking that it still would comply with the 2018 regulations. Some may not comply. So a qualified person must test the installation every 5 years and provide a report. On that report, that person will give a date when the next inspection is due. It must be conducted before the tenancy commences. If you've got people in the property already before the 1st of July 2020, you must do an electrical safety inspection by the 1st of April 2021 and provide the tenant with the report. And the landlords are to provide tenants with a copy of the inspection report before they occupy the property, as with gas safety, where we're talking about tenancies starting after the 1st of July, and any prospective tenant who asks for it, and local authorities can ask for a copy of reports which must be done within 7 days of the request. That may be where a tenant has complained to the local authority they've not had one, or that they don't think the electrical supply is safe. So the local authority must serve notice within 21 days of becoming aware of the lack of report. So this is a remedial notice on the landlord, and the landlord has 21 days to respond or must do the works within 28 days. If it's been brought in, if the remedial notice is not valid because of circumstances where there is a valid certificate or there has been an inspection, they have 7 days to confirm their notice or withdraw it. The local authority can arrange for the works to be carried out where the landlord has not complied with it and recover that money from the landlord. Remedial actual civil penalty up to £30,000, so it's a serious business, and there's no provision to allow the landlord to place the blame on their agent if they were relying on them to do the works, which is something that does happen with other things. The other thing with this is that it is going to, like section like safety and other things, you've got to do it before, give the certificate beforehand, and you have to, it will prevent you from doing a section 21 or serving a valid section 21 notice if you don't do this. So that is the end of the slideshow. I think we've got some questions, so I am going to see what they say. What is the burden of proof tenants have for action they take under the HFHA, Homes Fitness for Human Habitation? The burden of proof, that's a good question actually. I think actually because it's a civil claim, do you know what, I'll need to check that, because some of the, obviously the environmental type things are have a criminal burden of proof. But actually, no, the Homes Fitness for Human Habitation Act, that's under that will fall, claims will be under the civil courts as far as I'm aware. But that's a good question, and I will. So it's the burden of proof for civil is on the balance of probability, as opposed to the criminal, which is beyond reasonable doubt. But I will actually look into that, and actually I will. I can email you on that one, Chris. I'll email you. So George Mees, is there an update on when SAP 10 will come into force? Not as far as I'm aware, but again, I can look into that. I'll get back to you on that one. So James has said, I have a vacant rental property currently being refurbished and due to be remarketed shortly. Is it legal for the agent to ask for a rent guarantor should the tenants lose their jobs and not be able to pay the rent? It's currently almost impossible to obtain rent guarantee insurance. Yes, you can have a go. Absolutely, a lot of people do ask for a guarantee, and that's absolutely. Just make sure that your contract is watertight, and that your guarantor is obliged to cover the tenant's breaches after the fixed term as well. I've got a couple actually where I've had inquiries with people with guarantees, and the guarantees have not been particularly well drafted, and so there has been some wriggle room there. But I'll get back to the two that I was that have asked me questions there. But if there's nothing else, thank you for coming. Thank you for listening. If you'd like to talk to me afterwards, please do give me a ring or send me an email, and I'd be very, very happy to have a chat with you. Thank you very much.